Good morning, this is your Kelso Report for Friday, September 9th, and I'm your host, Clark Kelso. Well, it's not easy to sue the government for damages. The road to the courthouse doors are filled with procedural hurdles and potholes that, if you are not well versed in the detailed rules, can easily derail your action irrespective of the merits of your claim. That is what happened to the plaintiffs in Adams v. United States, which was going to be an action against the United States Bureau of Land Management under the Federal Tort Claims Act for damages to the crops of some 134 farmers, resulting from the Bureau's use of a pesticide known as oust to attempt to eradicate an annual grass on federal lands that contributed to uncontrollable wildfires. Soil contaminated with oust blew onto the farmers' neighboring lands, causing substantial crop damage. The plaintiffs filed their Federal Tort Claims Act claims with the Bureau to satisfy the requirement of exhausting administrative remedies before filing their action in federal court. According to Section 2401B of Title 28, when an agency denies an administrative FTCA claim, the claimant has 6 months from the date when the denial was mailed by certified or registered mail to file a complaint in federal court. After the expiration of the 6 months, the statute provides that, quote, the tort claim against the United States shall be forever barred, close quote. Because the FTCA is a waiver of the sovereign immunity of the United States, the courts have interpreted the 6-month limitation period as jurisdictional, and that period is not subject to equitable tolling or estoppels. So if you miss the filing date, your case gets dismissed for lack of subject matter jurisdiction. Well, you guessed it, the plaintiff's counsel missed the deadline by 1 day. Although it doesn't appear in the opinion, I'm going to speculate that someone made a little mistake in counting the days. Perhaps counsel counted the 6 months from the date of receipt of the letters instead of the date of mailing. In any event, counsel did not try to contest the conclusion that they had filed their action 6 months and 1 day after the date of mailing. Instead, the issue on appeal was whether the Bureau had properly mailed the denials by certified or registered mail. The Ninth Circuit joined other circuits in holding that an agency gets the benefit of the 6-month limitation period only if the agency strictly follows the requirement of sending the denial by certified or registered mail. It doesn't matter if the claimant actually received the denial. If it wasn't sent by certified or registered mail, the 6-month clock does not start running. So, to decide this case, the Ninth Circuit had to delve into the details of what constitutes certified mail under the United States Postal Service's regulations and domestic mail manual. It turns out that there actually are 2 ways of sending certified mail. The first is to go to the post office, fill out the certified mail forms, pay the fees, and have the certified mail receipt stamped as received by the postal worker. The second way is to fill out the certified mail form, put it on the letter, put enough postage to cover the cost of certified mail, and then just drop it into any post office mail drop, street letterbox, or any other receptacle for first-class mail. The post office will still process it as a piece of certified mail. The plaintiffs tried to argue that the letters were not properly sent as certified mail because the Bureau mailed the letters from the Bureau's own mailroom. The United States Postal Service did not inspect the letters or postmark the receipts before the items entered the mail. Unfortunately for the plaintiffs, the postal rules do not require that the receipt be postmarked or that the letters be mailed only from a post office across the counter. So the Ninth Circuit held that the letters denying the plaintiffs' administrative claims were properly sent by certified mail. And the plaintiffs' federal court action was therefore tardy by 1 day, and their federal action was therefore forever barred. This is going to be a tough result for the plaintiffs' counsel to deliver to 136 angry farmers. The lesson here for all counsel is to be extra careful with suing the government. The procedures are not what you are used to when suing private persons, and the courts are pretty unforgiving if you make a mistake. Well, in our second featured case, we have a state court habeas petition that's granted. Now, in California's prison system, being validated as a gang member is a one-way ticket to solitary confinement, or what is euphemistically called the security housing unit, where an inmate is locked up for 23 hours a day, virtually indefinitely, for years on end. The petitioner in re Cabrera had been validated as a gang member by the California Department of Corrections and Rehabilitation, otherwise known as CDCR. To validate a gang member under Section 3378 of Title 15 of the California Code of Regulations, CDCR must have 3 independent source items, one of which must constitute a, quote, direct link to a current or former validated member or associate of the gang, close quote. The 5th District defined direct link to mean that the source item must provide a connection without interruption or any intervening agency or step in the form of a loose relationship between the inmate and the validated gang affiliate. The only source items which CDCR found in the petitioner's possession were photocopies of drawings that had been signed by either a gang member or gang associate. The petitioner indicated that he did not know the drawings were gang-related, and because the petitioner participated in an art program at the prison, he possessed some 20 other drawings that were not gang-related. On these limited facts, the 5th District held there was insufficient evidence to support the validation charge. In particular, the court held that, quote, some evidence of a direct link is not shown by an inmate's mere possession of 2 photocopied drawings with photocopied signatures of the gang-validated artist authors of the drawings. We reject CDCR's position, stated by the Deputy Attorney General oral argument, that an inmate's mere possession of a gang affiliate's photocopied signature is enough to show a direct link between the inmate and the affiliate, close quote. Given this conclusion, the 5th District granted the writ of habeas corpus and ordered the inmate released from the security housing unit and returned back to the general population of the prison. And now we have 3 one-liners for today. First, in the area of the law of evidence. In United States v. Santini, the Ninth Circuit reversed a conviction for importation of marijuana and possession of marijuana with intent to distribute. The theory of the defense was that someone else had placed marijuana in his car before he tried to cross the border, and that the defendant was easy to manipulate or trick because he had suffered a traumatic brain injury in 2005. The defense put on a clinical psychologist who testified to the severe traumatic brain injury and to tests showing the defendant had permanent cognitive deficits. Well, the prosecutor responded in kind with an expert psychiatrist who testified that his evaluation did not show the defendant had brain injury, making him more vulnerable to manipulation. Part of that conclusion was based on his review of the defendant's rap sheet, which the expert claimed showed he had, quote, extensive prior contacts with law enforcement, close quote, before the 2005 accident. And that if the charges against the defendant were related to his injury, one would not expect to see similar behavior before the 2005 accident. The Ninth Circuit held this evidence was improperly admitted. Federal Rule of Evidence 404B permits some evidence of prior wrongs or acts in limited circumstances, but the evidence must be sufficient to support a finding that the defendant committed the prior acts, and those prior acts must generally be similar to the offense charged. Neither of these elements was met here, particularly given the fact that the psychiatrist conceded he had trouble even understanding the rap sheet. And most incredibly, the rap sheet itself was not introduced into evidence. The court also rejected admission of the testimony under Rule 703 as showing the basis for the psychiatrist's expert opinion. The problem here was that the psychiatrist clearly was not an expert in reading criminal history reports. Moreover, the court found the conclusion that the prior contacts were, quote, excessive, close quote, was far more prejudicial than probative. The court reversed the conviction and remanded for a new trial. Next, an issue under the special education law. In Michael P. v. Hawaii Department of Education, the Ninth Circuit held that Hawaii violated the Individuals with Disabilities Education Act and implementing regulations, which prevent a state from requiring exclusive use of a widely discredited severe discrepancy test to assess the existence of a specific learning disability that would qualify for special education services under the Act. Now, in all other states, you have a state-level Department of Education that provides policy guidance and oversight to local educational agencies. Under a 2004 amendment to the IDEA, and then regulations promulgated in 2006, the federal law was changed to forbid a state from requiring exclusive use of the severe discrepancy test, a test which tried to assess intellectual ability as measured by IQ tests versus actual performance. But the federal law clearly still permitted the local educational agencies the option of using the severe discrepancy test. In Hawaii, the State Department of Education is itself the educational agency that provides direct educational services to the public. So the legal question was whether the federal restriction on state policy regarding the severe discrepancy test should apply to Hawaii, given that it was also the local educational agency. And federal law gave local educational agencies greater discretion. The majority of the Ninth Circuit panel held that the restriction on states applied, and that Hawaii therefore cannot rely solely on severe discrepancy tests to determine the existence of a specific learning disability. The dissenting judge, who not coincidentally lives in Hawaii, noted that as a result of the majority's interpretation of federal law, quote, "There is only one school district in the entire country which is forbidden from deciding for itself whether to use the severe discrepancy model in determining whether a student has a specific learning disability. That school district is not one in which either of the judges and the majority live. It is where I live, the state of Hawaii," close quote. Seems to me the dissent has a pretty good point. The ultimate federal policy was to give local educational agencies discretion and to make sure that state policies did not take away that discretion. And when the state is also the local educational agency, it arguably should be permitted to exercise the discretion that Congress tried to preserve. But that's not what the majority held. Our final one-liner for today involves juvenile law. In In Re PC, the First District affirmed the juvenile court's conclusion that a baby under 1 year old who had serious medical problems, probably associated with drug and alcohol abuse by her mother, was nevertheless adoptable and likely to be adopted within a reasonable period of time. That conclusion was supported by direct testimony from 2 social workers and was consistent with the conclusion reached by 3 other social workers. The juvenile court terminated the mother's parental rights to facilitate the adoption, and because the mother, who was homeless, was no longer locatable. The implausible ground for appeal was that there was insufficient evidence of the child's adoptability because of her severe medical problems. But given the testimony of the social workers, there seemed to be plenty of evidence to support the juvenile court's judgment. In fact, the court expressed concern at the end of the case about the ethical dilemma posed to the appointed appellate counsel, who had never had any contact with their client since he was not locatable. As the court observed, quote, "Despite receiving no direction from her client and despite being aware of her client's apparent abandonment of any relationship with her child, counsel pursued a marginal appeal. For counsel, who has no reason to believe her client has any interest in this appeal, to take it upon herself to try to reverse the finding of adoptability, which was supported by the opinion of 5 experts, and thereby prevent the baby's chance of having an adoptive parent, raises, in our view, a significant ethical issue," close quote. It is a tough spot to be in for appellate counsel. Counsel was appointed by the court to represent the absent mother on appeal, and the court in essence seems to be suggesting that counsel should have been more sensitive to the interests of the child than the absent mother. But as the court noted in closing, perhaps this is an issue that is just unique to the particular context of appointed counsel in this sort of a family law case. Well, that's it for today's Kelso Report. Have a great day in the law.